This is ABC News legal analyst Royal Oakes welcoming you to Hinshaw Culbertson's Insurance Law Program, where we discuss insurance and reinsurance issues of interest to industry professionals. Here's your host, the co-chair of Hinshaw's Global Insurance Services Practice Group, Scott Seaman.
Welcome to Hinshaw Insurance Law. This is part one of our three-part series on cyber. On this episode, we will be discussing cyber breach notification, or data breach notification. Joining us is the savant of cyberspace, Anne-Marie Giblin. She is a partner in Hinshaw's New York office. Welcome, Anne-Marie.
Hi, Scott. Thank you.
So companies need to have an information security program in place before a breach. Could you tell us some of the basics that an information security program must have?
Yes, definitely. So there's actually at least 25 states that have data security laws that require you to protect certain information. And every state has a data breach notification law that requires certain breaches to be reported directly to the Attorney General. So when you put those two obligations together, it's really important that you have a foundation as a business to secure all the information that you have a legal duty to secure, but also the information that's important to your business that could end it. Any proprietary trade secret information is really important in this regard. So what are the main elements? Well, first, and especially when I work with businesses that are starting from scratch, it's best to know what data you have. So what data are you collecting? What are you maintaining, and how are you maintaining it? Where does that data live? So as a first step, it would be great to have a data map. Unfortunately, these days, those are really expensive to do. So if you have a capable IT team that can do this for you and identify the data you're collecting, maintaining, and using, that's a great first step for an information security program, because identifying the data is extremely necessary. Second is the way you're storing it. So usually I go to companies and explain to them, you want to identify your crown jewel data. So as we know, unfortunately, the Queen just passed away. The crown jewels are a great way to describe it, because the crown jewels are protected. They're really important. They're irreplaceable. So what data is that for your business? And that's the one we should secure the most securely. We're going to put that in a server that's segmented away from other servers. We're going to make sure that it's password and access protected, it's encrypted, and that we're really securing that data the most secure way that we can, and then moving out from there. And then making sure that all other data is categorized in a similar fashion. So we have crown jewel data, we have important legally protected data, we have everything else, or whichever way it works for your business. So data classification, data identification, and then security. And then you want to also have hardware assets. So where you actually have, I know how many endpoints I have. An endpoint is just a computer system, a phone, a tablet, something that allows access to your system. Having a classification and categorization of that will help you organize all of your data in an information security policy and get it together. Then you want to outline how you're protecting it. Now, you don't need details. I actually have a lot of pushback on this, especially from IT professionals, because they don't want to put that information out there. But from a legal perspective, if you give broad strokes that we use commercially available firewalls, we use multi-factor authentication, we use encryption, we keep our encryption keys away, we use access controls, and we use a change management policy, which goes along with access controls. Just outlining those steps and explaining them in the information security policy of your posture without giving details of, I use this brand of firewall or I use this brand of encryption, is a great way to do it legally, especially in the event of a data breach where you may have to give it over to a regulatory authority or your customers. And then finally, making sure that there's an element of cyber incident response in there. We actually have a great system at Hinshaw where we have 7 policies that we outline in our cybersecurity risk framework that fleshes that all out. And one of them is the information security policy, which is more specific just to the cybersecurity elements, but making sure that you mention cyber incident response within that and then referring back to your cyber incident response plan is really important.
So that's the cybersecurity program. And as you say, we've got a good framework for it, but it always then has to be customized and right-sized for the particular business entity.
That's right.
Let's talk about notice of cyber breaches. And we're in the context now of business-to-business cyber breaches. Who has to provide notice when there is a cyber incident or a data breach? Who must receive notice, and when and what type of notice has to be given generally?
So that's actually a great question, because in business to business, there's no specific regulations authorizing any of this. So when it comes to consumer information, I'm a consumer, I'm coming to your business. The regulations are really clear of when and what type of information needs to be reported. But business to business is trickier, because that's really based on contracts. So when we come to our contracts, and a lot of my day is actually spent beefing up these contracts, it really needs to be built into your contract. And it has to say at what point you consider a data breach. Now, there's a few hurdles to that. A lot of contracts, especially if you're a provider and you're giving a service like software as a service contracts, they want to define data breach very narrowly. They actually want to define it via the statute, which only covers consumer information and would not cover your breach of your business information. And in certain situations, for example, at a financial authority or financial services company, if you're sharing sensitive proprietary information or business information that has nothing to do with your consumers, and you define data breach based on the statute, then you're actually not getting anything, because they don't have to notify you unless it's an actual consumer involved. So you want to be very mindful of how you're defining data breach. You also want to be mindful of your obligations should there be other contracts or other needs that you have to report. So 72 hours is the golden rule in cyber breach, especially for financial services organizations. So generally I build in 48 hours. If you have a breach, I want to know 48 hours after you know. So it gives me time to then respond and make my notifications as well too.
So are there any regulations at all, Anne-Marie, that apply to business information, or is it solely to consumer or personal information that there's regulations for?
With regards to data breach, there's nothing specific about businesses. Obviously, there's trade secret and proprietary information regulations that would cover that in other contexts, but specifically with regards to data breach, no. And that's why it's really important to have in your contract. Because in a lot of situations, especially with your third-party vendors, they really don't have an obligation to notify you unless there's something independent really talking about consumer information. So again, thinking of the data, your crown jewel data, things that we talked about earlier, it's really important to make sure that if you need to share that with a vendor or a business partner, that you make sure that if something happens to that information, if it's compromised in some way, you need notification about that, because that could be a really bad day for your business, not with regards to data breach independently, because it has nothing to do with consumers, but for your own data security and protection.
And I take it you may be operating in an environment where your computer and informational systems are not fully available or available at all to you.
That's definitely a possibility. Ransomware in particular would be the worst scenario in that situation. And in the last 2 years, dealing with the COVID-19 pandemic, we saw the rise of ransomware as a service. Very similarly and a little scarily, we're seeing phishing as a service now, where people are devising really sophisticated phishing emails, attempting to get into your system. But the combination of those two things, where you have cyber criminals actually creating these programs and these malwares and then selling it to other criminals, is a concerning thing, because it takes a really long time to actually code a malware or code a ransomware program. So the fact they're becoming more easily available is a concerning issue.
Well, Anne-Marie, a lot of us would like to go back to the days when people were fishing for trout. But we thank you for joining us. Ladies and gentlemen, if you have any questions on cyber issues, please reach out to Anne-Marie in Hinshaw's New York office. This is Scott Seaman once again thanking you for joining us on Hinshaw Insurance Law.
The information on our insurance law program is provided for general information purposes only. Nothing stated on the program constitutes legal advice or creates an attorney-client relationship. You should consult directly with an attorney of your choosing if you'd like to obtain any advice with respect to any claim, case, or matter. Any views expressed are those of the guests and are not necessarily the views of Hinshaw Culbertson or any of its clients. For information on past and upcoming programs, visit the Insurance and Reinsurance page on www.hinshawlaw.com and click on Multimedia.